Employment Law This Week. I'm George Whipple. Our top story, the EEOC announces new nationwide disclosure rules for position statements. Retroactive to January 1st, employers should expect the disclosure of their position statements to the charging party, even if the statement contains confidential information. Under the new policy, complainants have the right to request access to the statement and respond to it, but any response from the charging party will not be disclosed to the employer in turn. Lauri Rasnick has more on what this means for employers.
Employers need to be thinking now more than ever what information it's comfortable providing to charging parties through this process. First, employers should think about whether it's information that they can describe in a general way instead of actually providing it to the EEOC. If the employer believes that this is information that the EEOC should see in order to make a full analysis, the employer needs to separately submit the confidential information, essentially under seal. The employer also has to provide the reasons why it believes the information is confidential. And at that point, the EEOC may or may not agree with that rationale. If it agrees with the rationale, the confidential information would not be provided to the charging party. If it does not agree, then that information could very well be provided.
Hispanic-is-not-a-race defense fails in the Second Circuit. When a Cuban-born lieutenant was hired as the new police chief of a Long Island town, a white police lieutenant filed a lawsuit claiming discrimination on the basis of race. A jury found in his favor. In trial and on appeal, the town argued that Hispanic is not a race, therefore there was no race discrimination. In a case of first impression, the Second Circuit ruled that Hispanic is a race under U.S. Code Section 1981 and Title VII. The NLRB cracks down on employers restricting the content of personal emails sent through the employer's email system. In 2014, the NLRB ruled that employees who have email through their employers can use that email to communicate about union-related issues. In a recent election at Blummer Chocolate Company, the union claimed that the company email rules interfered with the voting process. Employees were allowed to use the company's email system for personal emails, but were prohibited from expressing personal opinions in their emails to coworkers. The NLRB found that this rule interfered with elections and that a second election should occur. One of the questions that arises from this ruling is the issue of where the line is between what employers can prohibit, harassment for example, and what they cannot. We'll have more on this topic as it develops. Employers' use of big data to track the health of workers is quickly becoming a privacy concern. According to a recent Wall Street Journal article, firms providing wellness services and insurers are now using algorithms to identify employees who may be making big health decisions. This includes workers who are trying to conceive, considering surgery, or looking for a new doctor. While only aggregated data is shared with employers, the article raised privacy concerns because companies may be able to identify employees with medical issues based on the data. Regardless of the information available to them, it's important for employers to ensure that employment decisions are not in any way affected by the information they receive. ADA, GINA, privacy, and other theories or claims might be used by creative plaintiffs' counsel if employers don't exercise care and caution in this emerging area. Now it's time for our tip of the week. Stuart Scott, General Counsel for Daiwa Capital Markets America, Inc., is here with some advice on providing in-house client service.
Always remember who your client is. Your client might be and probably is the organization that employs you, but not necessarily its employees, its directors, its business units. And their interests can differ. Get out of your chair. When you have an important legal issue to address, it's best to go see the people involved, talk to them face to face in the environments they work in, see what they actually do, see the documents they deal with. Finally, always keep in mind that in today's world, business is global. It's also increasingly regulated, but those regulations are still very local. They're local to the jurisdictions where they arise, and they're also local to the regulatory regimes even within a jurisdiction. And they can be very inconsistent. Always keep that in mind, that business is global, but the regulation's local.
Thanks, Stuart. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.